Today we're here with Dylan Adams, a patent attorney with Davis Wright and Tremaine, which is a massive patent a firm. And he's also written a book called Patents Demystified, which is used by the American Bar Association, Stanford, Harvard, MIT, and I'm sure the University of Houston, my alma mater, uses it. I'm surprised you didn't add them in there. And he also has a YouTube channel, which is how I found him, oddly enough, called Patents Demystified as well. I have links to all of this stuff down in the description. So thanks for joining us, Dylan. We're glad to have you.
Yeah, you bet. Glad to be here.
So the reason I reached out to you is I'm involved in lure design, lure making, and I always see these kind of discussions explode on Facebook, online about, oh, you can't make this lure because it has a patent. You can't do this because it has a patent. And, you know, when I start digging into them, most of the time they don't have patents. They end up having trademarks. But I think a good place to start would be, my understanding is that the field of law is intellectual property. Is that
right? Yeah, exactly. So yeah, that's going to be what's going to be protecting these things is intellectual property in general. And then the four types of intellectual property that, you know, that are possible are going to be patents, trademarks, copyrights, and trade secrets. But when it comes to lures, really, you know, trade secret isn't going to be applicable because, you know, you're going to be having stuff that's public. Maybe if you had like, you know, bait compositions, you know, that were secretive or maybe a secretive process. But really, I think what we would want to talk about here is going to be trademarks and patents. Copyrights are related to artistic works. As artistic as lures are, you know, the law sees them as being useful articles. And so they're going to be covered by patents. And then the branding stuff, that stuff is going to be covered by trademark.
Okay, great. And so my understanding is there's also two different types of patents, at least, maybe more?
Yes, exactly. Yeah. So the two that are applicable to lures, and I think I sent you some examples of both of these. So there are utility patents and then there are design patents. So utility patents cover functionalities of things, and they also do kind of cover design. So in some ways it's kind of confusing, but they can cover sort of a physical article. They can cover methods of manufacturing, methods of using things. Whereas design patents, they cover one very, very specific design. So they're a lot more limited and narrow, but they're a lot easier to get through. And especially with things like lures, where if there's not a lot of functionality to them and it's just sort of, you know, like the surface contours that are new and different from other things, a design patent is going to be more relevant to something like that. Whereas if there's more functionality, or if it has a unique design, it's more complex, a utility patent may be the way to go with those things. But that's something you want to talk to your patent attorney about. Is, you know, sometimes we actually file both. We'll do a design patent and a utility patent on the same thing and protecting sort of the ornamental design of some pieces, but then some functionality of other stuff as well.
Yeah, so we can pull up one of those patents right now. This is a utility patent.
Yes.
And, you know, can you, like, all these patents I look at have these crazy drawings. Well, they're not even crazy drawings. It looks like somebody drew it by hand, and then all these numbers. And so these numbers, I think, relate to points down here usually. Is that correct?
Yeah. So usually, so there's really three parts of a patent application and an issued patent. There's going to be the description, and that's called, some people will call it the specification. And then there's going to be the drawings, which you kind of point out. And then there's going to be the claims, which that's the section you have up right now. And so it's the claims that actually define the metes and bounds of what is owned and not owned in the patent. So think of it like a legal description on your house. So if you're going to be selling your house, you're going to be putting out pictures of stuff on the website or whatever. But what really determines what you own in terms of the house and the land, it's that legal description, right? It's not pictures of pictures of stuff. It's only that legal description that really says, hey, this is the land that I own versus what I don't. And the claims are just like that. The claims define the metes and bounds of what's protected and what's not. And a good example of that is, so for instance, a lot of times the claims are just a subset of what is in the description and the drawings. And people usually look at the drawings and description and say, well, all of this is protected, you know, by the patent. That's completely untrue. A lot of times it's just a small subset of that, or something that's really narrow and specific. So you kind of have to look at that claim section to really determine what's protected and what's not. And that's the big mistake that a lot of folks make when looking at patents.
So the question I would have is, so these are all numbered obviously here. And is it kind of, is this like all inclusive, or is there like ors between these things, or there's ands, you know? So if if I had this, let's take this random lure, for example, if I had like the same thing, but without this top part, number 18,
right?
Is that now not infringing, or is that kind of a case by case basis?
Yeah. So essentially, look at the claims. It's perfect then. So the way you do an infringement analysis, you have to infringe at least one claim of an issued and enforceable patent. That's another thing to keep in mind, is that like a lot of times you'll be looking at patent publications. These things are publications of pending applications or applications that went abandoned, and people will freak out and be like, "Oh my gosh, like, you know, these claims are so broad and they cover me." It's like, well, this application never issued. It's 10 years old. It went abandoned. It didn't go through. It's not an active issued patent. So that's something people should keep in mind. This one is an issued patent. So for instance, here, like, let's look at claim one. So to infringe claim one, you have to have all the elements in each of those lines. And here there's no ors. It's going to be an and thing, right? So, let's start with the first one. So a fishing lure comprising. Okay, right. So you're probably going to have a fishing lure comprising. Then the next thing would be, the next line is a first connecting rod having opposed first and second ends, the first end of the first connecting rod being secured to the fishing line. So you would look at your product and say, does it have that or does it not? And then you go through each of those elements. And if your product has all of those things, you would be infringing that claim one, and therefore would be infringing the patent.
Okay.
That kind of makes sense?
Yeah. The thing I love about trying to read patents is they're all in English, but half the time I have no idea what they're saying.
Exactly. It's really confusing. You have to actually go to the description to kind of understand, like, well, what do they mean by a first connecting rod?
Right.
It's probably one of these rods. Maybe it's 21 or maybe it's 20. I would guess it's probably 21. But that's when you look at the description and say, well, what do they mean by connecting rod? And what do they mean by, on opposing first ends and the connected rod being secured to a fishing line? What do they really mean by that? And that's where the description kind of helps out. It sort of lets you understand what the claim terms mean, and sort of how to, define, what it is that they're talking about.
Okay.
So they kind of get into the description, and that's where, if you go back a bit lower, that's going to start having the numbers and stuff in there, to specifically what all these things are.
Well, okay. Yeah. So here's the figures and
exactly
all these things. Okay. Wow. Woo.
I know. Yeah. It's one of the things where, it's not intuitive and easy to read patents. I mean, I've been doing this for a long time, and, I'm good at it, but it is not an easy, intuitive thing. So, if people have difficulty with it, you are not alone. Patents are difficult to read, and difficult to understand, like, what is protected and what's not. And
Okay. So this is a utility patent. Correct. Mostly because it shows functionality as opposed to, not as opposed to, but kind of, they're claiming functionality over claiming solely design. Is that a fair statement?
And with this, there's enough complexity in the design that they can use a utility patent. There's going to be, obviously, there's something in there that is new and non-obvious over the prior art. That is things that exist in the field. And that's the requirement of getting a patent. So your invention has to be new and non-obvious over the prior art. And prior art is any technology disclosure that's already out there. So, it could be issued patents, it could be published patent applications, regardless of whether they issue or not, or it doesn't matter, whether they went through, but it could be really anything. It could be existing products, it could be technology disclosures. Like, I work a lot in the sciences, so like scientific papers, that could be prior. Really anything that was known before you file, that is going to be prior. So here, there was something in there that was new and non-obvious compared to, what was already out there. And it's going to be in the complexity of how these things are connected and what's on the end of stuff. So there's, something in there, it makes it enough that, it would be new and non-obvious compared to other things. Simple designs, those probably wouldn't be covered by a utility patent. They wouldn't be new and non-obvious from a utility standpoint, but from a design standpoint, small little changes can be patentable over things that already exist. And
you could take two things that have existing patents and combine them in a non-obvious way and come up with something new that's patentable. Is that correct?
That's exactly right. And that's really most common, is a lot of times, a lot of things are totally known, but the way you combine things, if that is new and non-obvious, or if you're using it for a different functionality compared to what it was used before, or you do things in a way that's sort of surprising compared to the way that other people have done it, maybe they'll even teach away from doing it that way. Those things can sort of, help your case when it comes to being new and non-obvious of the prior art.
Cool. So let's take a look at a design patent real quick for, looks like a worm.
Totally.
And so I've never actually looked at a design patent before. So we have this picture here that has a worm, which is pretty standard fishing lure worm. It does have an interesting design that I haven't seen before, but what is actually being patented here?
Yeah, so in some ways, design patents are a lot easier to interpret than utility patents. So here we have one claim. The claim is the ornamental design for an artificial worm slash stick bait fishing lure as shown and described. So here, the drawings actually are the protection here. It's not the words of the claims.
Okay.
So here, the design patents are going to be line drawings of every sort of side of it. So you're going to have the side, and that's what those little dots are. Those are the ends of it. You want to have that as well. That's part of the design also. So really, to determine infringement is, okay, how close are you to this design? And if you were to put your design compared to what's patented, would people be confused by the two? It's a little bit of a, squishy determination. It's not always easy to tell, but that's how you do a determination when it comes to design patents. And that's why they're so narrow is, you have to be very, very close to this in order for it to be infringing. Okay,
so that brings up an interesting question that we'll kind of dive into that came up from, I posted in a few of the Facebook groups that I was in for lure designers, what kind of questions you'd want to ask. And, one of the questions I got was, I have an existing mold to make baits, or I have an existing bait and I modify it, the mold or the bait, is that still covered under patent? So we can use this design patent, for example. If I took this and added, I don't know, like a third layer, or if I see over here, we have these ends here. Right. If I added a different end that looked nothing like any of these, is that still covered? Is that not covered under this patent? How does that kind of work?
Yeah, so in this case, the only part that's actually protected is going to be the stuff that's not shown in dotted lines. So the different ends, those are just examples of what can be on the end. What's really protected is the stuff that's drawn in the solid lines. So you could have all sorts of different things connected to it, but if you had that portion that was exactly the same, the sort of the dark portion, then you would be infringing. And then the next question is, well, how much do I have to change to not be infringing? That's not an easy determination a lot of times. It's sort of it's definitely a gradient of, of sort of protection is, the farther away you get from this design, the less likely you're going to be infringing. But the real question is, how likely is somebody going to be to actually sue you for infringement? I mean, I've been involved in a lot of patent litigation where people are clearly not infringing. Something is really different, but they say, well, I disagree. I'm going to sue you, and I'm going to, pursue this because I have a bunch of money, and they can pursue it regardless of whether there actually is infringement or not. And that ends up in some ways being more of the issue. You ideally don't want to have things be exactly the same, but even something that's really different, you're not guaranteed to not be infringing.
Yeah, so let's put a placeholder there because I want to come back to that, kind of process of how you would discover you're infringing and stuff like that. So I'm not asking you to render a legal opinion, obviously, but, simply adding another, ring here is probably too close, but changing this whole ring area into, I don't know, a giant wing or something is probably far enough away,
Yeah, totally. I think that's fair for sure. Like, just adding one additional ring, someone would look at it and they'd be like, I see this as being equivalent, right? But you're saying, if you add a bunch of wings and a bunch of additional structures, I think your average person would say, well, this one's different. This one has a bunch of other wings and a bunch of other things. It's not the same as this, right? Yeah. And I think that's a great example of sort of extremes where, minor changes, that's probably not going to do it. But bigger changes, that'll almost likely do it.
And the other interesting thing I see here is there's no kind of idea of scale. So, yes. and I guess that just doesn't come into the design. This can be 1 millimeter or it could be 50 yards long, right?
Correct. That is one place where there's a lot of variability is in terms of scale. Relative scale, proportionally, for instance, if you have one portion that's really big and then, one portion is really small compared to that, that may get around a design patent. For instance, like the section with the rings, if you had really big rings and then the shaft was really small, that actually may be okay. But proportion-wise, you're exactly right. I mean, it could be a foot long, it could be in the millimeter scale, but as long as that design is there, the overall proportions, don't really matter.
And the other thing that strikes me here is I'm not certainly a patent search expert. I have performed some, but like, how do you even search for this?
These are really hard to search for. And that's one thing that frustrates a lot of people is they say, hey, look, I want to be a good citizen. In the business world, I don't want to intentionally infringe on people. I want to know if I'm infringing on patents. And they try to do a patent search. And if you've ever tried to, which, it sounds like you kind of did some research for this, it is absurdly difficult to do searches on patent stuff. The keyword stuff isn't very easy, especially with designs. Like, honestly, I let professionals do the design searching because it is really difficult and time consuming. But the short answer is it is not easy to do. And it's not the kind of thing that is a lot of times cheap and effective to determine whether infringing or not. So a lot of times what I say is, look, just go ahead and do what you're going to do. If you're aware of products that have patents on them, try to, not infringe on those things. But you can spend a long, long time going down the rabbit hole trying to find things that you're potentially infringing and just not find them. They're really hard to find them.
Right. So I think that's a good segue into kind of what the kind of general course of patent infringement notifications, how they come about. My understanding is usually you put a product out on the market, and after probably it becomes a little successful, someone comes along and sends you an email and says, hey, you're infringing on my patent. Is that kind of the basics of how it usually works?
Yeah, that's pretty typical. Usually the way people will start is they'll send somebody what's called a cease and desist letter saying, hey, we found your product. We know that it's out there. We'd like to make you aware of, or we maybe even more aggressively say, we think you're infringing our patent. Maybe it'll be really some of those, they'll just kind of give you the patent number and leave it at that. Or maybe they'll actually have a claim chart, and kind of like what I talked about with the utility patent claims, they'll actually do a chart and do that analysis and say, hey, here's what we're seeing in your product. Here's where the correspondence is, and this is why you're infringing. Sometimes they'll go to that level. But yeah, where you start out typically is doing a cease and desist letter via email or, via actual, snail mail.
Right. And so a cease and desist is really just kind of putting you on notice, saying, hey, you just FYI. And it also, my understanding is it does kind of set a date at which you can no longer claim you weren't aware that you were infringing. Yeah, sure. And then there's, I believe it's like 3 times the damages if it ever gets to that part from that date.
Exactly right. Yeah, totally. Yeah. So if people are aware of a patent and intentionally infringe it, they can be liable for what's called treble damages. And that's just a fancy way of saying triple damages.
Yeah.
And so, yeah, right. Like, why do attorneys do stuff like that? Like, why do you make things all difficult? The world's difficult as it is, that we have to use these fancy terms. Like, why can't you say triple instead of treble? Right?
I just put 3x on there.
Yeah, right. But yeah, so, and then, you could be potentially liable for treble damage, at least at the time of when you send that letter. But sometimes you can prove that they were aware of this before that, and maybe you could get damages before, actually you sent the letter. But yeah, you're right. The letter does set a date when people are aware of things for sure.
Right. And so from that point on, if I receive that letter about one of my designs, I have a couple of courses of action right off the top, right? I could just stop selling that altogether, say, hey, I'm sorry, I've closed it down, liquidated that, I'm going away. I could certainly continue on doing whatever I do and just say, come at me. Or, I can probably engage with a patent attorney and say, hey, look at this, what do you think? And so at that point, if I went the attorney route, where do you kind of pick up in that process? What's your first step, I guess?
Yeah, so the first step is going to be doing that infringement analysis. So especially with utility patent applications, we're going to kind of go through element by element and compare that to the person's product. Say, hey, are all the elements there? And if, for instance, let's say, maybe all those elements are there and that person would infringe those claims, then what we might do is kind of do an invalidity analysis as well, because just because a patent has issued from the patent office doesn't mean it's necessarily guaranteed to be valid. A lot of times the patent office, the examiners are super busy. They can't find all the prior art. They only have a super limited amount of time to search for these things. And they might miss some really relevant prior art, things like existing products. A lot of times they honestly don't do searches of existing products. They're going to totally miss those things. And so we'll do a really extensive prior art search and maybe find some stuff that would build a case and say, well, okay, you have this issued patent, but it's invalid because there's something that was exactly the same that the examiner didn't notice. and that was going on 10 years before you filed your patent application, okay, maybe you would literally infringe these claims, but the patent is invalid. And that may be an analysis we would want to do as well.
And so in that case, threaten is too strong of a word, but you're basically telling the patent holder, like, hey, you can go away, or we're going to go to the patent office and give them this prior art and maybe invalidate your patent completely.
Yeah, for sure. Although, a lot of the stuff is so expensive, and that's the difficult thing about litigation is, and it's a positive and a negative thing. So on their side, if they want to actually file a patent lawsuit, it's pretty expensive. I mean, it's going to be, typically it's going to be in the tens, if not hundreds of thousands to get these patent lawsuits off the ground. And so there has to be sufficient damages there to be able to justify that. Even with treble damages, I mean, like kind of the margin and, how much stuff, lures go for.
Right.
You have to sell a lot of lures to make it worthwhile to sue somebody. And that's why a lot of times, to be honest, I mean, we'll get cease and desist letters, and it's like, the infringement there is like, a lot of times we just won't even respond. We're like, whatever. We know that you're small enough that you're not going to be able to, file a lawsuit against us, and you probably know that this patent is either invalid or we're not actually infringing, and you're just hoping that this person is dumb and isn't going to talk to a patent attorney, is just going to be scared and say, okay, I'll take a license, or I'll stop doing what I'm doing, or whatnot. That's kind of the weakness with cease and desist letters. Is a lot of times we just tend to ignore them because if somebody is really serious about something, you can tell in their letter, and they'll just file a lawsuit straight out of the gate.
Right. Yeah. And I'm just thinking about, typical margins as I understand them in the fishing lure business. You're making $1 or $2 per bag of lures. Yeah. So you're going to hit me for $3 a bag? Like, oh no.
Yeah, right. So, the treble damages. Yeah, exactly.
Treble damages.
Maybe, luckily, maybe $1,000 worth of damage or something, and you're going to spend $100,000 on your patent attorney just to get the lawsuit going. It makes absolutely no business sense whatsoever. But most people don't realize that. That's why it's great that you're having this discussion and informing people about this, because people are scared off by this sort of stuff. And I would say talk to a patent attorney. A lot of times it's not that expensive and time consuming just to get a basic analysis and just kind of get a sense of, okay, am I infringing or am I not? What's the business case here? What should I do?
Yeah. And, again, with my limited experience, being involved with some patents, I've never really seen one that's cut and dry unless someone just said, yeah, I saw the exact patent and I copied the exact thing. Right.
Okay. There's always arguments that you're not infringing or that their patent is invalid. And, everybody on each side thinks, oh, it's 100% on our side. We don't infringe. We totally infringe. Yeah. Usually it's going to be somewhere in the middle. That's exactly right.
Yeah. And I mean, I didn't do any research prior, but I can't even think of any court cases over fishing lures. Right.
It would be unlikely, I would guess. Because it's the kind of the stakes usually aren't going to be high enough for things to actually go to court, and a lot of times things are going to settle well before any lawsuit starts.
Yeah, so let's talk about that real quick. The settlement side is, from my understanding, generally involves like a licensing agreement. Typically, like you would, if I was the person infringing on the patent. Yeah. And you were the patent holder, I could say, look, I'll give you 2% of all my sales or something like that. And I'll get a licensing agreement and we'll go about our business. Is that kind of a typical settlement or?
It really depends on what the patent holder wants. Some people, they just want to exclude other people from being able to make, use, sell, offer to sell, and import things. And that's sort of the core of what the patent right is. So people just say, I don't care what royalty you give me. I don't want anybody else in the market doing what I'm doing. And that's one of the things you can say is like, look, you have to stop what you're doing. You have to burn all of your product. You have to ship it to me. And you can't do this anymore. But some people, it's more of a business thing. It's like, look, you have to get a royalty, and here's what, a royalty that I would request that would be sufficient. Or maybe, a lump sum of $10,000 plus an ongoing royalty of 5%. It's really, there's a lot of different variations of what people can request. And it really depends on the parties and the business case and what people want.
And, let's just say we're going to set precedents in the fishing lure world and go to court. I've heard numbers thrown around like, you're $1 million in at that point on either side to
Yeah, I mean, especially for complex cases, I mean, you're going to be looking at easily $1 million. With lures, it's probably a little bit less than that, but you can easily stretch into the hundreds of thousands of dollars, even on a simple lure case, having to do all the due diligence on stuff and, do all the motions and things. That's why stuff very rarely goes to trial. The stakes just are not worth it. And, the lawsuits are notoriously unpredictable, and especially getting to trial. Most people just want to settle before that, because that's when it gets expensive as well, having to drag stuff through trial.
Right.
You think reading a patent is boring, having to sit through a patent trial where you go through that language for hours upon hours upon hours. Like I once talked to a judge and I told him, hey, I'm a patent attorney. I'm actually, sitting, going to be eligible to be a federal barred attorney to bring patent cases. And he looked me in the face like, don't you ever bring a patent case into my courtroom. It was just like, it's like, don't bring that stuff to me. I'll be irate, because they're bored to death. It's like quibbling over what does this term mean? What is it, first member versus the second member, and this rod and that rod. And it's right. Totally boring. People hate it. The jurors hate it. The judges hate it. Yeah.
Well, that's, kind of the other thing that came to mind is, it's a trial by jury. You're going to get 12 random people off the street. And while I might know fishing lures very well, you might know fishing lures very well, those people don't know anything, right? Totally. So we're arguing over minutia of rods and fishing lures, and these people are just like, oh my God, what are you doing, man?
I don't care about this. I mean, if anything, fishing lures would be great. I mean, you think about like I do a lot of software stuff, and that's even worse. But so I barely understand how to turn on my computer and check my email. You're trying to understand querying databases and and protocols. I don't know what the hell this stuff is. People just tune out and their eyes just close. Right. Yeah. That's why patent cases are horrible, and everybody hates them.
Yeah, absolutely. So before I want to touch on trademarks, but before I touch on that, in kind of your opinion, what in the fishing lure kind of space is there really anything that you would spend, I'm assuming, several thousand to $10,000+ on patenting? What in your mind would kind of reach that level of?
Yeah, no, and that's a great question. I think that's one of the things a lot of people who are startups or individual inventors really lose focus of is is there a business case for actually spending all the money? And you're right. I mean, a lot of times it's going to be in the thousands and most likely tens of thousands of dollars to get a patent through. Design patents tend to be cheaper. That maybe in just you could probably get a design patent for under $10,000 if you're lucky, if things go well. But utility applications, those are going to be at least $10,000, including the examination phase. I mean, you're looking at maybe 20 to 30 if it gets really bad, if it's really, really complex. And so you have to consider that. And most people think, hey, I have this great idea, I want to patent it, but step back. I mean, what is the market for this? I mean, how much money are you really going to make on it? Are you going to be able to even recoup those costs on that one lure? And what are these benefits for you? I mean, is this going to be one product of many, or are you going to have to file patents on all of these things? A lot of times it doesn't really make sense. So for instance, if you're looking to, have a startup and, if it's going to be something where you're going to be selling the idea to somebody, a lot of times you will file what's called a provisional patent application. And then you can take that idea and try to license it to folks. But you don't want to spend the extra money on having to file the really expensive and formal non-provisional patent application and go through the examination process. You want to file a patent application so that you can get it in front of somebody, so you can at least have perceived ownership of something, but you yourself don't want to actually have to take it there. It's just way too expensive and you're not going to have the ROI. But say that you're going to, take it to Cabela's or Dick's Sporting Goods or things like that, and you're going to license something, you would at least want to file a provisional patent application, which can be done. People can do it themselves for a few $100s. Using an attorney can be in the thousands of dollars. You can file a provisional patent application, and then that can be sufficient to just, then be able to take the idea and license it and move the business forward.
And so the provisional patent, is that what I see things like patent pending? Is that kind of where that provisional piece comes in?
Yeah, so patent pending is going to be whether you have a provisional or non-provisional. Maybe I should just sort of step back and kind of talk about these provisional versus non-provisional.
Yeah, I think that'd be good.
So there's two ways to start the patent process. One is by filing, like I said, the non-provisional patent application. And that is the really formal application that is expensive because it has a lot of these specific requirements that the USPTO, has these applications, must entail. Like you have to have very formal line drawings that you've seen, and the description has to be in a certain format. So you file this non-provisional patent application. It waits in line for 1 to 3 years before the examination phase begins. And the examination is kind of like a negotiation. So think about like American Pickers or Pawn Stars. It's like that, right? It's not a binary thing where you have a patent or you don't. It's a question of, do you have a really broad patent that covers a lot of different things, or do you have one that is so narrow and so specific that you could make one tiny little change and get over the claims in the patent, right? And that's what the negotiation is between you and the examiner. The examiner has to confirm that what you have is new and non-obvious compared to what the prior art is. You want to have the broadest claims possible. Hopefully the examination goes well and this negotiation is successful. You have the examiner have issue, get a notice of allowance. You pay an issue fee, and the application issues as a patent. So that's starting with a non-provisional patent application. So for startups, very few startups do that. They'll start with what's called a provisional patent application. So the provisional patent application, it's just a placeholder. It only lasts for 1 year. It's not examined. It just sort of sits there at the USPTO. And then you have to file that non-provisional patent application at the end. The good thing about the provisional patent applications is they're pretty inexpensive. I mean, you can use really any technology disclosure. It doesn't have to have a formal description. A lot of times what I tell people is draft a description of what your product is in as much detail as possible. Even have ugly hand-drawn sketches, and I'll kind of, massage that and file that as a provisional patent application. And that's sufficient. That gets you patent pending status. It gets you a priority date. That allows you then, say, talk to investors or talk to people you want to license it to, and be able to put patent pending on the product if that's the route you want to go. But you're also still patent pending all the way through from the provisional to when you file the non-provisional up until the application either goes abandoned, like you give up, or it issues from an application to a patent. Then it goes from being patent pending to patented.
Great. So let's take a veer off into trademarks, because this one comes up all the time, right? I see people say like, "Oh, the Senko is patented," right. And now again, we've already covered how patent searching is a little difficult, but it doesn't appear to be patented. But the term Senko is trademarked, and we have that over here. And so, what does a trademark get you that is as compared to a patent?
Yeah, exactly. And this is where you're right. This is where a lot of people get confused. They sort of, use patents and trademark interchangeably, but they're totally different. So trademarks are intimately associated with specific goods and services. Okay, so for instance, like Senko, they may have a trademark on Senko related to fish bait, but let's say that you have a mechanic shop. You could call it Senko as well, as long as people aren't confused that they would think that Senko, the mechanic shop, is the same Senko as the lure people, or if you have Senko software or Senko apple farm. A lot of times you can find great examples where the same trademark is used by different people, but they can all use it together because there's no confusion. People wouldn't think, well, somebody who sells apples, they're also creating lures, right? Or somebody who creates software, they're not creating lures. So then those trademarks can be interchangeable. And that's sort of the big difference between patents, where it's like you have one thing, it doesn't matter how it's being used. If it meets those claims, then it's infringing.
Yeah, so this one has Senko on there, and it says for fishing lures. So that's where you would kind of figure out, if I'm making a fishing lure and calling it a Senko, yeah. But if I'm making a car and calling it a Senko, then I'm not infringing.
Yeah, exactly. Yeah, and so the question is, but for some companies, for instance, like big companies, like say, like Google. Google does so many things that a lot of times their trademarks are to a level where it's hard to do, really to do anything, because, they could easily get into certain markets, or maybe they're already in all these markets. So for a company that's very specific, like Senko, they're probably going to be very limited to lures. If you do something that's even remotely different, you're probably not going to be infringing. Whereas, if it's something like Google, you probably can't use Google for anything. Or McDonald's, they're notoriously litigious, and anything that says McDonald's, even if it's like a family name, you might get sued for trademark infringement, even if you're using it as your family name.
Yeah, well, I don't know if it was the most famous, but I remember Apple, the computer company, had to acquire a license for the Apple, the music, the Beatles label, because they were getting into music, and then it was all a big mess there. Yeah.
Yep, totally.
And so the other thing I kind of think I know about trademarks is, and maybe this applies to patents as well, is the holder of the trademark or the patent has to kind of show a record of attempting to enforce it kind of unilaterally. They can't kind of pick or choose, say, well, I like Dylan, so he's infringing, but I'm not going to send him a letter. But I don't like this guy, so I'm going to send him a letter. Is that relatively true?
Yeah, for trademarks, that's definitely the case. You have to enforce your mark, and if you don't, you can actually potentially lose your trademark. That it's like you've effectively abandoned it. So yeah, you actually have to actively police your trademark. Not so much the case with patents. You can actually be a lot more selective. And I mean, maybe if you affirmatively, like say on your website, say, hey, we're not going to enforce our patents, and then until you change your mind and you decide to, okay, maybe that can be used against you. But a lot of times you don't have to actively go against people to enforce patents. That is one another difference between patent and trademarks.
Yeah, because I remember we had the startup I was at, we got, our company was called White Hat, and Red Hat sent us a trademark thing. And we were like, what? And so they just wanted us to say that we wouldn't get into the operating system business. And we were like, okay, sure. So
sounds good to me. We weren't doing operating systems anyway.
Yeah. A few $1,000s to attorneys later, we're clear, right? So
yeah, totally. The attorneys are the people who only win and stuff like that.
Exactly. So, but would you say it's safe to say that if you see another company out there using a name for their fishing lure, you just shouldn't use that same name?
I think that's a good way to go. I mean, for a couple reasons. One is because, you could potentially be allowed for trademark infringement, but two, it's just sort of being just a good person in the business space. And if anything, that's a good thing to sort of notice about trademarks is that's the purpose, is to be able to identify goods and services. So if you see a Senko brand fishing lure, it came from Gary Yamamoto lures, right? That he made it, right? And that's the problem is that if people have knockoffs, a certain quality of Senko products. Maybe that's a high quality, maybe that's a low quality, maybe it's middle of the line, but you know what that is, right? And so having another thing that is a knockoff of that, it could be super low quality and that erodes their brand. And that's really the purpose of trademarks, is to sort of preserve that brand identity so you can trust in those names.
And so and this really, I don't think applies to fishing lures in specific, but if I'm designing lures, I'm bringing them to market, what is, and I have a name that I think is catchy or whatever, I'm going to put some advertising dollars, some marketing dollars behind, what's kind of the process of deciding, should I get a trademark on something? And then actually, if I decide yes, going forward with it.
Yeah. So one thing about trademarks is unlike patents. So with patents, you actually start losing patent rights upon a first public disclosure, public use, or offer for sale of something, right? And so at some point, what you're doing could be dedicated to the public, and you could lose all of your rights, and it's unpatentable just because you sold it or you've shown it online or things like that. Public disclosure, public use, or offer for sale. Whereas with trademarks, you actually get some provisional rights by using these things in commerce. And some people don't actually even do a federal registration for a trademark. They just sort of have a common law trademark, and that can be sufficient to give them the protection that they want. But as far as people who are thinking about themselves and they have a brand they want to protect, they have a name, they have, say, a logo or a business name or a product name, whether they should trademark that. So, it's good to do a search, kind of just look at products, like go to Amazon and put that in and see what pops up. Is there anything similar? You can do a search at the USPTO website, the United States Patent and Trademark Office, go to their trademark section and do a search there for the name, see if anything pops up. But a lot of times it's pretty cost effective to go to a trademark attorney and have them do a search. And unlike patents, where a lot of times, look, I tell people, don't do a patent search. It's a waste of money. It's a way that most patent attorneys kind of upsell you on worthless, worthless services. Doing a trademark search is actually very, very useful. A lot of trademark attorneys used to be former trademark examiners at the United States Patent and Trademark Office, and they can essentially do an examination and know, for sometimes, a few $100s, what are the chances this is going to go through or not, and really can provide some valuable information.
Yeah, because the trademarks there's word marks, which is literally just the word.
Yep.
And then there's, the kind of graphic logo side of things. But if it's a word mark, like you can literally go to the trademark website, type in that word, and it pulls up, right? So I'll put a link to that in the description. A lot of times is like, oh, well, what if it's capitalized or lowercase? Or what if I add add an S on the end or things like that? Those things, talk to an attorney, but a lot of times, that's not going to make a difference. If there's going to be confusion between the two marks, it's not going to work to, use a 0 instead of an O, or add an S and make it yours plural or something, or, you hyphenate yours instead of having it be all one word. A lot of times that's not going to do. Yeah. I think the way I look at trademarks is that, do you know that person's, can you easily tell that person's trying to confuse you, right? So Senko with an E, if I do Senko with an I, like, yeah, and it's a fishing lure that looks like a Senko, like, yeah, it's clearly, I'm trying to, I'm trying to capitalize off Gary Yamamoto's name that he's spent all this money and made famous, right? So, so yeah, it's, that seems pretty cut and dry, but, people get confused by it all the time, so.
And I think in the end, people kind of know themselves. They know what they're trying to do. If they're trying to sort of ride the coattails of somebody else's brand, it's probably not a good idea to do that, right? And I think that people just kind of look themselves, if you're trying to be sneaky and try to, like I said, capitalize on somebody else's hard work in building a brand, it's probably not a good idea. But, if you're trying to do something that's completely different, you may accidentally be doing something that could be infringing, but that's a very different case. And, usually you can find a brand that's, going to be trademarkable and that isn't going to infringe on somebody else.
Right. And so, there is one area that the patents and the trademarks I've seen come into play that is kind of outside the normal legal world. And that's, selling online, specifically on Amazon. Amazon has a way that if, I see somebody that I think is infringing, I can report them, send them my, my patent or my design or my trademark. And by and large, at that point, you can't sell that product on Amazon anymore. Amazon is not going to jump in and examine your patent and see if it's valid or whether they're just going to cut you off. So, that's
design patents, not necessarily for utility patents, because that's a lot more difficult to do an analysis of. But for designs, they're pretty good about shutting people down if the design is pretty close. And like you said, for trademarks as well, they're pretty good about trademarks and they'll get involved, but not really for utility patents. Since that's, a lot more difficult of a determination.
Right. Yeah. So that's interesting. So another question that we got is, which is really esoteric, but it's, if let's say a lure does have a patent on it, right? Someone in a foreign country, generally, I know this exact example they're trying to get to, but someone in a foreign country makes a mold to where I can produce that lure. I then produce that lure, and I think he says for personal use. So we'll touch on that. But so there's the personal use case, and then there's the selling case. Yeah. So for personal use, is there any issues there at all that you can think of?
Yeah. So with personal use, it's like, well, there's got to be some exemption for personal use, and technically, no, absolutely not. It doesn't matter whether you're the producer, whether you're selling it. If you are making, using, selling, offering to sell, you are potentially infringing on that patent if that person wants to go against you. That being said, a lot of times, one, there's a practicality of like, if you're using something for personal use, well, what are the damages there? Why would somebody go against you? Right? It doesn't really make sense to do that. Also, it can be kind of uncool to, in the legal world, to go against the actual people who have the product. So, for instance, like if you buy a knockoff product, even knowing it's a knockoff product, you're a single person, it kind of is considered uncool to go after the actual customers themselves. That's sort of a consideration. But also consider too, is like, well, how is this person going to know that you're infringing? Unless you are flagrantly being like, look at me, I'm totally ripping off Senko, and they can suck it, right? You're probably not going to get people upset and have people going against you. Then maybe they'll do it even if it is just you, and they know about just to have a shot across the bow and tell everybody like, look, nobody should be doing this. We're going to make an example of you. So I guess what I say from a practical standpoint, it's unlikely that somebody would actually come against you, for patent infringement. But it's certainly possible, especially if you're like really aggressive about it and do things that really upset people, and they may want to make an example about you, even if it's really expensive for them, and if they're not really even going to get damages.
Yeah. So technically, it's illegal. It's the same as any other way, but they don't have people staking out the lake and the beach looking for you. Right?
Yeah, exactly. So, there's no patent waste. People have to enforce their patents on their own, and especially small companies, they barely have time to do their basic stuff and then go out and hang out and go fishing. They don't want to spend time policing their patents and going around to random web chats, be like, oh, I saw this person who they use this thing that's similar to mine, and it's. What are the chances they're going to find it? That does happen every once in a while. I certainly see people, they run in the same groups and like, there's this person, they're using my stuff. And some people get really upset about it, and it doesn't matter cost. Like they just, they really are insistent they want to stop people, even if it's for personal use. Not always, but yes, every once in a while.
Yeah. And so for a business, just because I bought the mold from some random person in a foreign country, that doesn't give me any sort of protection or leeway at all, does it?
No, but it depends on what the claims are. So a lot of times the claims are going to be to the physical thing itself. So having the mold may not be infringing, but once you actually make something, so again, it's making, using, selling, offering to sell. If you make that product, once you've made it, that's an infringing product that you have created with that mold. A lot of times the molds themselves aren't going to be infringing. They're something totally different. That's just a mold. But yeah, once you create the product, that product is then infringing. Yeah, regardless of where it came from. And to use the example of sort of like foreign stuff. So each patents are jurisdiction by jurisdiction. The US patent is only valid within the bounds of the United States. So you can stop people from importing something. So let's say from this foreign country, they make a bunch of these lures. Once they import it or they try to import it, someone who has a US patent can stop them from doing that. But if you don't have a patent in that specific country, you wouldn't be able to stop them from manufacturing or selling in that country. It'd be only at the border when they're trying to import it or once it's actually being sold in the United States.
And I assume that, it just sounds like that at the border piece is a nightmare to enforce.
It depends on the stuff. Actually, strangely enough, like Border Patrol does a lot of, patent and trademark stuff where they can be pretty good about it. Especially for bigger products where they can identify it easily. Yeah, they're actually pretty good about stopping knockoffs. It can be in some ways more efficient than like actually going to court. You should get an order saying, hey, these people are, they're infringing. We want to stop them at the border. That can be in some ways easier than, trying to, go to people once it's actually in these random stores. Like, how are you going to find it once it gets distributed?
Yeah. So I just want to back up on something that you mentioned that is interesting. The mold of a fishing lure, this is called a design patent, is not infringing typically?
Typically, no. It depends. Sometimes you may have claims to a mold. And actually, even recently, I did design patents on mold specifically. And so, if they have a design, they can have a design patent on the mold, or maybe somehow there's like a method of manufacturing that includes the mold, and it would be something where it'd be contributory infringements where this mold could only be used to be creating these infringing products with this infringing method. Maybe it'd be contributory infringement, but a lot of times, yeah, the mold itself wouldn't be infringing if all you have is the design patent itself, or if it's a utility patent. A lot of times, yeah, the mold itself wouldn't be infringing.
Yeah, I guess that's interesting because technically the mold maker is not making the infringing design. He's simply providing a tool to allow someone else to infringe on your design.
Yeah, right. And then, they may get kind of caught for contributory infringement. If for instance, like if the only thing that can be done with this mold is doing something that is legal, you may be able to have a cause of action against those people, but that's a lot harder. It's usually easier when they actually have the actual product itself.
Right. Yeah, that's interesting. All right. So I think we covered all of the community stuff. Do you think there's anything that we've missed out that we want to cover here?
I guess one would be kind of the business case as far as, if somebody has an idea and that they want to patent it, what is, the best advice for that? Because a lot of people make mistakes with, what they're doing, and they'll either forfeit patent rights or they waste a ton of money by needlessly filing patent applications a lot of times too soon. So here's kind of my suggestion is, like I said earlier, so patent rights start to be lost upon a first public disclosure, public use, or offer for sale. So ideally, consider that you may need to file your patent application before you do things. In foreign countries, you typically automatically lose your rights. In the US, you have 1 year from a first public disclosure, public use, or offer for sale to file a patent application. Otherwise, you lose your rights. But still, that's why the best thing to do is actually just to not do any public disclosure, public use, or offers for sale before filing anything, because you may not be thinking about foreign rights. But for instance, I see this a lot of times with startups who are like, well, we don't care about foreign rights. That's not a big deal to us. But then they get an investor who says, hey, we have a huge market in Germany. I hope you preserve foreign rights. And they're like, well, we didn't think it was important until it totally was. And we lose a great deal because we didn't preserve foreign rights. So again, before you do any of those things, you're going to want to file a provisional patent application. Another example is if you're going to be approaching a licensee or investors, file that provisional patent application before you talk to those folks. Because, being in a startup, I don't know if you've done pitches to investors and things like that. They don't want to sign non-disclosure agreements. People say, well, I'm going to have people sign NDAs. And like, look, that pegs people as being a newbie. People are going to be insulted by it. They're not going to want to sign NDAs. So the way to get around that is just file your provisional patent application, then be able to go in and you'll say, hey, I'm patent pending. That lets them know, you have at least perceived ownership. And if they were to try to copy it, which honestly very, very rarely happens. What may happen is people may have been working on that independently, but very rarely are companies going to steal ideas. That's a lot more rare than people think it is. But so you file your provisional patent application, then you can go into these meetings and you can talk openly about what the product is, and that's going to be more likely that you're going to be able to get a deal. So that's the issue that people have a lot of times is they say, okay, I have this idea, I want to file a patent application now. But no, don't do that. Ideally, wait as long as possible. Do R&D. Prove the business case, because you can have a really clever idea that's awesome, but is that clever idea going to turn into a good product, right? Can you manufacture that product at a price point that people will actually buy? Is it something that is going to be a good product? And people don't usually take that step. They run and they spend tons of money on filing a patent application, or maybe even they'll file a patent application and wait until the examination phase, and they spend tons of money, tens of thousands of dollars, without ever even determining whether this is a good business idea or not. And that's sort of the unfortunate thing is, do that business analysis up front before you spend the money, even on a provisional patent application. Make sure it's worthwhile.
Right. Yeah. I mean, having a $15,000 patent on a product that made you $2,000 in its lifetime is not good business, right?
Not good business at all. Yeah. Think of it, patents are a means to an end. They're not the end in and of itself. And it's not, patents aren't the business model. And they aren't the pot of gold in the rainbow. And it's not like, hey, I get my patent and suddenly, people are going to notice and they're going to shower me with money. That's not how it works. You have to go out and you have to sell your product. You have to show people, how valuable it is. It's a lot more difficult than people usually anticipate. A mistake that people make is they think, okay, I need to file my non-provisional patent application, wait 1 to 3 years before examination begins, go through all the examination phase, which is expensive, and then get my issued patent, and then I'm going to be selling it. No, don't do that. Take your product and start selling immediately after you file your provisional patent application. Start pitching it to investors, start pitching it to licensees after you file that provisional patent application. Don't wait on things. All you need to do is get patent pending status, then go ahead with the business.
Yeah, and something you mentioned there is, at the beginning, people stealing your ideas, right? Yes, it has happened, but I think, most people just don't want to deal with that headache, right? They're not going to steal your idea. They might give you a bad deal and give you, crappy license agreement or something, but they're not going to outright steal it. Exactly. But also on the other hand, what I usually tell people is, okay, let's say that you have the idea for this great fishing lure, and Pure Fishing, who is like the largest fishing conglomerate in the world, steals it.
Yep.
What are you going to do?
Yeah.
Right? Like, are you going to spend, hundreds of thousands of dollars defending it? Like, those guys probably have patent attorneys on staff that'll just sit there all day, and it's free for them, right? So
it's sadly, you're exactly right. It's sadly a money thing. The people with more money tend to win, and it's sort of a sad reality of the legal system. And folks like that, if they wanted to bury you, they'll bury you in litigation, and you're never going to be able to make it. There are some examples where the underdog wins, but you spend so much energy and so much money on something like that, a lot of times doesn't really end up being worth it. But like you said, it's very rare that people are actually going to be stealing ideas truly. What's mostly the time is actually happening is somebody has a general idea, but these companies are working on these things independently. They have a R&D staff, and they may have been working on these things independently, and so that happens more of the time, if anything. But
I mean, I know in the fishing lure space, right? I mean, we're basically mimicking bait fish in nature, and there's only so many of those in North America, right? And so, and the patterns of how you would mimic a fin is roughly the same all over the place. So, you're not going to invent something that people have generally not thought about before. And like you said, I know, these companies employ armies of designers to figure this stuff out. And it's rare that you see someone come up with something so novel that no one's ever come up with it, and then it explodes. I think the one that most people bring up is the banjo minnow. I don't know if you ever remember seeing those commercials.
Oh, no.
It was like this, as seen on TV kind of lure.
Oh,
and
totally,
I don't know if they have a patent on it or not, but it was kind of a huge hit only from, it was an infomercial fishing lure.
Right.
And, they sold a ton of them. And, but I'd have to see if they have a patent on it. It looked like just a regular minnow, right? It didn't look like anything special. So, so that's great. Well, hey, thanks, Dylan. I really, really appreciate your time and sharing your expertise with our little corner of the patent and intellectual property world. I'll put links to Dylan's YouTube channel, his book, which is super easy to read, I've been told. I have one on order. I haven't got it yet. So,
Nice.
If you want to dig into patents in general, you can get the book. And Dylan, I'll put your email out as well if someone wants to contact you, or no?
Sure. I mean, yeah, if you want to, but people can, come to my channel and they can maybe leave a comment, and definitely people should comment down below if they have additional questions. I'll try to monitor the comments and answer questions if people have additional questions. But yeah, if you got any value as video, give it a like, give it a comment down below. Let us know, kind of what your additional questions are. I'm sure this raised additional questions for you. So, I'd love to answer questions, down in the comment section here, or if you want to come over to my channel and, I'll answer questions there as well.
Yeah, Dylan does a great job of explaining, again, relatively complex patent and intellectual property things on his channel. So that's how I found him. Again, thanks again, Dylan. Really appreciate it. Take care, everybody.
You bet. Thanks for having me.